Hi everyone, this is a video on patent. Please watch my previous videos on intellectual property rights IPR and copyright. Links for these videos are given in the description. The word patent seems very fascinating to us, but many of us do not know the correct meaning of this word. This video will provide information relating to patents. Okay. First of all, let us see what is a patent. A patent is a type of intellectual property. We know the best known types of intellectual property are patents, copyrights, trademarks, and trade secrets. So, a patent is a type of intellectual property. A patent is the property right granted by the government to an inventor. A patent is an exclusive right granted for an invention. In other words, a patent is an exclusive right to a product or process that generally provides a new way of doing something or offers a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. According to the World Intellectual Property Organization, this is the definition of a patent. An invention can be a product or a process. A patent is an exclusive right granted for an invention. This means that once you have patented an invention, no one else can make use or sell whatever you have created without your permission. Okay? Furthermore, a patent gives the inventor the legal right to exclude others from making, using, or selling an invention for a limited period of time in exchange for publishing and enabling public disclosure of the invention. This means a patent for an invention is granted by the government to the inventor. So it gives the inventor the legal right to stop others for a limited period, normally 20 years, from making, using, or selling the invention without the expressed permission of the patent owner. The granting authority issues a patent in exchange for permission to publish details about the invention, such as how it is made and what it is used for. Okay. Now we will see what kinds of inventions can be protected. Patents may be granted for inventions in any field of technology. An invention can be a product or a process. Actually, an invention refers to a process or product that aims to solve a specific technological challenge. Inventions may be from an ordinary kitchen utensil to a nanotechnology chip. An invention can be product such as chemical compound, or an invention can be a process, for example, the process for producing a specific chemical compound. Okay. Many products, in fact, contain a number of inventions. For example, a laptop computer can involve hundreds of inventions working together, right? Okay, now we will see which act governs the patent system in India. In India, the patent system is governed by the Patents Act 1970. The Indian patent law is defined by various provisions of the Patents Act 1970. Okay. Under this law, patent rights are granted for inventions covering a new and inventive process, product, or an article of manufacture that are able to satisfy the patent eligibility requirements of having novelty, inventive steps, and are capable of industrial application. As I mentioned earlier, an invention can be a product or a process. Under the Patents Act, exclusive rights are granted for inventions. Okay. What are the rights of patentee as per the Patents Act 1970? Here we will see the rights granted by a patent as per the Patents Act 1970. As per Section 48 of the Patents Act 1970, the rights of a patentee are where the subject matter of the patent is a product, the exclusive right to prevent third parties who do not have his consent from the act of making, using, offering for sale, selling, or importing for those purposes that product in India. So, other one, uh, where the subject matter of the patent is a process, the exclusive right to prevent third parties who do not have his consent from the act of using that process and from the act of using, offering for sale, selling, or importing for those purposes the product obtained directly by that process in India. This means if the patent is granted for a product, the patentee has a right to prevent others from making, using, offering for sale, selling, or importing the patented product in India. So another case, if the patent is granted for a process, if the patent is granted for a process, the patentee has the right to prevent others from using the process, using the product directly obtained by the process, offering for sale, selling, or importing the product in India directly obtained by the process. Okay. Next, the question that comes to our mind is the Indian patent valid worldwide? Patent protection is a territorial right and therefore it is effective only within the territory of India. There is no concept of global patent. What does it mean? Patents are territorial rights. In general, the exclusive rights are only applicable in the country or region in which a patent has been filed and granted in accordance with the law of that country or region. An Indian patent is valid only in India. Okay. Next, what are the criteria of patentability? How is an invention to be patentable? An invention is patentable subject matter if it if it meets the following criteria. What are the criteria? Number one, it should be novel. Actually, novelty or newness. The invention must be new and not similar to any other inventions or existing products. Okay. Number two, it should have inventive step or it must be non-obvious. So what does it mean? Non-obviousness or inventive step. Any product or process that involves an inventive step and is capable of being used in the industry is called an invention. Actually, this definition makes it clear that the invention must have an inventive step and it must not be known to any skilled person in that particular field. Okay. Now the third criterion, it should be capable of application. Industrial application. We can say usefulness or utility. This is another important criterion for granting patents. An invention must be useful and have an industrial application besides being new and non-obvious. Okay, so these are the three essential criteria that have to be fulfilled in order to get a patent for an invention. Okay. What is the term of a patent in the Indian system? The term of every patent granted is 20 years from the date of filing of patent application. That is, patent protection is granted for 20 years from the filing date of the application. Okay. However, for application filed under national phase under Patent Cooperation Treaty (PCT), the term of patent will be 20 years from the international filing date accorded under PCT. Okay. Now, let us see types of patent. There are three types of US patents, namely utility patents, design patents, and plant patents. Strictly speaking, the protection offered by Indian intellectual property laws do not always fall under the category of any type of patent in US. That is a very important point. We will see these three types one by one. Utility patents. Utility patents may be granted to new inventions, advances in technology, and processes. Actually, utility patents may be granted to anyone who invents or discovers any new and useful process, machine, article of manufacture, or composition of matter, or any new useful improvement thereof. These are the patents that cover how a product or process functions. Okay. Furthermore, the term utility patent is not used in India. There is no such type of patents in India. In general, a patent granted in India serves the same purpose as a utility patent in the US. In general, utility patent granted in US and patents granted in India are similar in nature. The term utility patents in India is not used. Instead of this, the term patent is used. Okay. Design patents. Design patents may be granted to the ornamental design of an article of manufacture. A design patent covers how a product looks. A product's usefulness has nothing to do with it. Moreover, the design patents are in the US. Okay. The registration and production of industrial designs in India is administered by the Designs Act 2000. The industrial design recognizes the creation of new and original features of new shape, configuration, surface, pattern, ornamentations, and composition of lines or colors applied to articles which in the finished state appeal to and are judged solely by the eye. Okay. Plant patents. Plant patents may be granted to inventions or discoveries of asexually reproduced distinct new varieties of plants. Actually, plant patents exist in US. Plant patents may be granted to anyone who invents or discovers and asexually reproduces any distinct and new variety of plant. Okay. There are no laws in India that allows for patenting plants. In India, the Protection of Plant Varieties and Farmers' Right Act 2001 is an act to provide for the establishment of an effective system for protection of plant varieties, the rights of farmers and plant breeders, and to encourage the development of new varieties of plants. Actually, India never allowed patenting plants as such because patents on innovations relating to plants such as genetic sequence are just as detrimental to farmers as patents on the actual plants. Okay. Okay, now we will see the importance of patents. Why are patents important? Patents provide inventors with the ability to protect their inventions. That is, no one can manufacture, sell, or import your patented invention without getting inventor's consent. Okay. Patents allow inventors to use their patented inventions or processes and profit from them exclusively for a period of 20 years. That is, a patentee can make or get profits from their patented inventions for 20 years. If a person is the first to patent an invention, he or she will get superior rights over subsequent patents. That means being the first to patent an invention gives the patentee superior rights over subsequent patents. Okay? Patents allow patentees to license their patents for others to use for fee or royalty, which is agreed. That means patents allow you to license your patents for others to use for an agreed up royalty or fee. Right? The patent system promotes innovation. Okay? Further, patents give incentives to software companies, high-tech companies, and drug manufacturers. It is obvious if there is no innovation, people will get no new products or innovative thinking. Right? Patents provide more credibility to companies and investors. That is, having patents provides increased credibility to both the investors and their companies. Okay? Information relating to patents. We can find the history of Indian patent system, the provisions of the Patents Act 1970 and its amendments, patent journals, and the information related to patent applications at www.ipindia.gov.in. Okay. In this video, I explained the basics of patents, that is, what is a patent and what kinds of inventions can be protected. Also, I outlined some important provisions of the Patents Act 1970, that is, rights of patentees, the criteria of patentability, and the term of a patent. Furthermore, I explained types of patents in the US and their equivalents in Indian intellectual property laws. Finally, I highlighted the importance of patents and information relating to patents. Okay, I hope this video has provided a good insight into patents and related information. Okay.